throughout his career and has received numerous awards and accolades for his contribution to the legal profession. Mr. Azam Nazir Tar.
Thank you so much, Honorable Speaker, for the kind words. Honorable Speaker, National Assembly of Pakistan, Honorable Deputy Speaker of Azerbaijan, my fellow panelists, Excellencies, Honorable foreign dignitaries, heads of political parties from all across the Pakistan, members of Parliament, ladies and gentlemen. It's a matter of great honor for me being part of this historical event, the Golden Jubilee celebrations of our Constitution. I must congratulate the Honorable Speaker and his team for organizing such a wonderful event for us and for our foreign dignitaries. We'll be talking about the Constitution in the changing world, balancing stability and adaptability. The first question posed would be that what challenges do constitutional democracies face in the 21st century, and how can they adapt to meet those while maintaining their core values and principles? Ladies and gentlemen, looking at the past decades, there are considerable challenges to democracies that have emerged, such as the rise of hybrid democracies, populism and nationalism, corruption and state captures, decreasing levels of truth in politics, and rising conflict and migration waves. If unaddressed, these threats could endanger the hard-fought gains in new democracies, as well as corrode democratic principles in established democracies. Many populist outsiders come to power speaking on behalf of the people, but often doing so in ways that seem to challenge basic norms of liberal democracy. Now, overcoming polarization. While some partisan polarization is healthy for democracy, one of the key drivers of the democratic decay in new and established democracies is intense polarization. Democracies acquire authoritarian features when political actors reject the democratic rules of game, deny the legitimacy of opponents, encourage violence, and curtail the civil liberties of opponents. Now, another feature is the globalization, economic inequality, and democratic disconnect. The third major theme is the indirect ways in which unequal economic resources diminishes the quality of democracy through voting, institutional design, campaign spending, and media. Widening economic inequalities and a deepening gulf between the political elites and those they represent are eroding the sources of legitimacy on which the viability of regime rests. Organized as vehicles for the formation of democratic will, the weakening of political parties is now under discussion. They are felt to be remote from their members and beholden to powerful backers. Political parties are now often perceived as mechanisms that function to manage supporters' expectations rather than challenging their collective will. Since constitutional democracy requires a stable political party system that provides for partisan contest within a rule-based framework of government and opposition. This development also weakens the authority of this type of governing regime. Challenges to judicial independence, media integrity, civil liberties, and several fundamental rights, such as freedom of expression and freedom of movements, threaten democracies. How should basic constitutional structure adapt in response to crises such as the revolutions, wars, local and global economic disorders, pandemics, and/or natural disasters? The subnational governments at the regional and local levels play an important role in the prevention, management, and recovery from natural disasters and pandemics. These jurisdictions are responsible for providing frontline services that are crucial for effective crisis management, including health care, civil protection, public order and safety, and for rebuilding lost or damaged physical infrastructure in the recovery phase. New businesses opportunities and the reallocation of resources from declining activities towards emerging opportunities are vital to recovery. Governments will need to avoid locking in old economic structures and business models, facilitating the creation of new firms and ensuring competition that can help underpin such restructuring. Investment in high-speed broadband communications networks that are part of economic stimulus packages must be accompanied by regulatory frameworks which support open access to networks and competition in the market. Such investment should also aim at stimulating the use of information and communication technologies, commonly known as ICTs, to secure economic and social benefits. Linking ICT investment with other large physical infrastructure investment, such as buildings, roads, transportation systems, health and electricity grids, allow them to be smart and save energy, assist the aging, improve safety, and adapt to new ideas. The crisis also represents an opportunity to raise investment in human capital, support for education and training that can accelerate the healthy transition to new jobs and emerging opportunities. It is also essential for innovation, which requires a broad set of skills. Building such skills starts in primary school and continues through firm-based training and lifelong education. Ambitious policy to address climate change makes economic sense to improve efficiency in the use of energy and materials, to move towards more sustainable manufacturing, and to develop new green businesses and industries. Examples are immediate win-win policies that governments can take advantage of, which include remove subsidies to fossil fuel-based energy production and consumption, cut trade barriers to climate-friendly goods, address market failures that prevent improvements in the energy efficiency of buildings and transport systems, reform policies that could achieve a given environmental objective more effectively. Ladies and gentlemen, how have the spread of emerging digital technologies and social media affected fundamental laws of the countries? The spread of emerging digital technologies pose broader challenges to fundamental rights, which must be addressed in order to maintain the quality of our democracy. Because data is held on a vast scale, the risks and impacts of its misuse are also vast. The dark end of digital spectrum threatens not just privacy and safety, but undermines free and fair elections, jeopardizes freedom of expression, information, thought and belief, and buries the truth under the fake news. It seems clear that the digital world has been beneficial for freedom of expression and information. However, technology has created another problem from the pre-digital era: human rights violations committed in the name of national security and counterterrorism, even by democratic and human rights respecting governments. This is one of the issues. Political participatory options have increased with new forms of communication, but in practice, the imbalances and problems are continuous, and manipulations and populism are real threats that diminish the stability of coexistence. Online harassment, trolling campaigns, and intimidation have polluted parts of internet and pose very real offline threats. Digital technology has brought many challenges to the enjoyment of human rights, to security, and to the governance. The test for governments, private sector actors, members of civil society, and the technology community is whether, through multi-stakeholder collaboration, they can develop proactive and holistic policies that ensure that technology is used to increase both freedom and security, and that the benefits of digital technology is spread to people around the globe. How has the globalization, immigration, trade flows, knowledge economy, and international commitments and agreements affected basic and fundamental law of national jurisdictions? This is another challenge, sir. The development of globalization brings about fundamental changes not only in the economy, in society, and in politics, but also in the law. These changes affect the areas subject to legal regulation, the technologies of communication and travel, the expanded economic areas, and the political opening of states lead to increase in cross-national communication, international dispersion of production system, transnational trade, global markets, mobility of people and businesses, and offshore investments. These processes have both desirable, socially advantageous effects as well as effects that are damaging to society. So it's two ways. In the private law context, parties in different jurisdictions sign contracts of sale, multinational enterprises from competition limiting cartels that affects the world market, and through the dissemination of files in internet. Copyright violations occurs in a multitude of states simultaneously. The term globalization helps to remind that new communications technology means that companies really can have global reach and local operations without actually establishing themselves with permanent regional or national headquarters, which is almost going on in especially the social media platform things. The fact that human rights groups cannot easily fix such non-state actors in a certain place has led us to believe that some of these global actors are everywhere and nowhere at the same time. Similarly, public law is confronted by cross-border cases when emissions damaging to the domestic environment are released from foreign territory. Foreign suppliers offer gambling via internet. Multinational concerns divert profits to subsidiaries located in offshore tax havens, and financial supervisory authorities control the sale of foreign financial products. In criminal law, corresponding challenges arise when in the prosecution of transnational terrorism and global organized crime and economic crimes, cross-border investigation are coordinated and access to persons or evidence abroad obtained, and we need to have a close interaction and cooperation in this regard in future. In the area of international criminal law, new problems arise when armed groups attack foreign territories rather than their own country. It is a seamless transition from cross-border activities which take place in the territories of two or more countries to activities of global magnitude whose effects are felt at around the world, and which can only be solved by joint efforts of the world community of states. One of the reasons why we are here to discuss these issues and find out solutions as well. As a result of this increasing need for cross-border regulation, the traditional law of nation-state is confronted more and more frequently with transnational activities that affect several states, endanger legal decisions that must be enforced in foreign territory, and raise issues that can only be solved on a global level. In summing up, ladies and gentlemen, we must realize that in order to live better and do good in modern times of globalization, we need to have constant and smooth interactions amongst the states. Thank you very much.
Our next speaker is Honorable Farooq H. Naik. Mr. Farooq H. Naik is the former Chairman, Senate of Pakistan, and is currently working as a senior advocate, Supreme Court of Pakistan. He has played a vital role in shaping important policies and legislation during his tenure. He has also been awarded Nishan-e-Imtiaz for his tremendous services to the nation. Janab Honorable Farooq H. Naik Sahab.
Bismillahir-Rahmanir-Rahim. Honorable Speaker, National Assembly, Honorable Deputy Speaker of Milli Majlis, Azerbaijan, Senator Faratullah Babar, parliamentarians, ladies and gentlemen. Constitution is the fundamental legal document that outlines principles and values of a state and provides a framework for governance. Constitution also protects citizens' rights and freedoms by limiting government's powers and ensuring that it operates within defined territories and boundaries. In Pakistan, Constitution plays a critical role in ensuring stability and continuity of state. It provides a clear set of rules and procedures for the functioning of the government, which helps maintain stability of the state. However, With changing times, Constitution needs to adapt to evolving needs of society. This can be achieved through amendments and reforms that reflect changing social, political, and economic landscape of the country. 75th anniversary of Pakistan, of the Constitution of Pakistan provides an opportunity today to reflect on the need for balance between stability and adaptability of the Constitution. Stability is necessary because it provides a clear set of rules and procedures for functioning of the state, which helps ensure continuity of the state. Constitution stability also promotes confidence in the government, which is crucial for maintaining law and order and economic development. However, adaptability is equally important because it allows Constitution to address changing needs of society and reflect aspirations of people. Constitution's adaptability can be achieved by making changes that reflect changing times while preserving fundamental principles and values of Constitution. Thus, any changes to the Constitution need to make a responsible and in a balanced manner. In this context, Pakistan's Parliament plays a critical role in ensuring that Constitution is amended in a responsible and balanced manner. Till date, 26 amendments to Constitution have been passed by Parliament of Pakistan. Today, we are observing 75th anniversary of Constitution of Pakistan, which is encouraging us to address 4 key questions that this conference has raised. Let us address one by one. The first question is, what challenges do constitutional democracies face in the 21st century, and how can they adapt to meet these challenges while maintaining the core values and principles? In my view, constitutional democracies in the 21st century face several challenges, such as rising inequality, polarization, erosion of trust in democratic institutions, spread of disinformation, and growing influence of non-state actors. These challenges pose a threat to core values and principles of constitutional democracies, such as individual rights, rule of law, and representative government. To meet these challenges, constitutional democracies need to adapt and evolve. That is, one way to do this is by ensuring that democratic institutions remain responsive to the needs and aspirations of citizens. This can be achieved by increasing citizen participation and engagement in decision-making process, promoting transparency and accountability in government, and strengthening rule of law. Another way to meet challenges facing constitutional democracies is by investing in education and civic literacy. Finally, constitutional democracies must work together to address global challenges such as climate change, terrorism, and migration. Collaboration and cooperation can help build trust and strengthen democratic institutions while also addressing shared challenges facing international community. The next question is, how should the basic constitutional structure adapt in responsive to crises such as revolutions, wars, local and global economic disorders, pandemics, natural disasters, etc.? In my view, crises such as revolutions, wars, local and global economic disorders, pandemics, natural disasters, and other emergencies can have a significant impact on basic constitutional structure of a country. In response, constitutional democracies must adapt their basic structure to address these crises while maintaining core values and principles of Constitution. Constitutional democracies can also adopt by incorporating new technologies or tools to facilitate crisis management. For example, digital platforms can be used to disseminate information and coordinate emergency responses. In all cases, adapting basic constitutional structure must be done with careful consideration of the core values and principles of the Constitution. Any changes to Constitution must be made in a responsible and balanced manner, considering impact on individual rights, rule of law, and representative government. Changes must also be subject to oversight and review to ensure that they remain necessary and proportional to the crisis at hand. The third question which has arisen is, has the spread of emerging digital technologies and social media affected the fundamental laws of a country? In my view, spread of emerging digital technologies and social media has had a significant impact on fundamental laws of countries around the world. On the one hand, digital technologies and social media have provided new opportunities for citizens to engage with their governments and participate privacy, rights, and raise concerns about surveillance and state control. Finally, emerging digital technologies and social media have created new challenges for regulating online content. Global nature of digital platforms means that content can be created and disseminated across borders, making it difficult for governments to regulate or enforce laws related to hate speech, incitement to violence, and other forms of harmful content. Spread of emerging digital technologies and social media has had a profound impact on fundamental laws of countries around the world. While these technologies present new opportunities for democracy and citizen engagement, they also create new challenges for privacy, individual rights, and rule of law. Countries must adapt their fundamental rights to the digital age to address these challenges and ensure that democratic institutions remain resilient and responsive to the needs of citizens. Finally, the question with regard to how has the globalization, immigration, trade, capital flows, knowledge economy, and international commitments and agreements affected basic and fundamental rights of national jurisdiction. In this regard, in my view is that globalization, immigration, trade, capital values, knowledge economy, and international commitments and agreements have had a significant impact on the basic and fundamental laws of national jurisdictions. These forces have created new challenges for traditional notions of sovereignty and territoriality, as well as for protection of individual rights and democratic governance. Globalization and international trade have created new opportunities for economic growth and development, but have also challenged the ability of national jurisdictions to regulate economic activity and protect local industry. Growth of multinational corporations and global supply chains has created new challenges for tax and regulatory frameworks, and globalization of financial markets has created new challenges for financial stability and regulation. Immigration has also created new challenges for national jurisdictions, particularly in area of citizenship and border control. Movement of people across borders has created new demands for legal frameworks that balances rights of migrants and refugees with need for national security and border control. Knowledge economy and the growth of digital technologies have created new challenges for intellectual property and privacy laws. Ease with which information can be disseminated across borders has challenged traditional notions of territoriality and created new opportunities for cross-border collaborations and innovation. Finally, international commitments and agreements, such as trade agreements, human rights conventions, environmental treaties, have created new obligations for national jurisdiction to uphold and protect fundamental values and principles. These agreements have also created new opportunities for international cooperation and collaboration, but have also challenged the ability to national jurisdictions to regulate in areas that may conflict with international obligations. National jurisdiction must adapt to these new challenges to ensure that fundamental values and principles such as individual rights, democratic governance, rule of law are upheld and protected in the face of global forces. These are my views with regard to the questions that have been raised in the 70th Constitutional Convention or Conference. Thank you. Thanks a lot. Thanks a lot. Thank you.
Thank you. Thank you, Naik sir. Our next speaker is Mr. Farhatullah Babar. Mr. Farhatullah Babar is a former senator who has served the Senate of Pakistan from 2012 to 2018. As a senator, he championed the cause of human rights, freedom of press, and transparency in the governance. He also served as the spokesperson of the President of Pakistan from 2008 to 2009. He is a prominent civil society activist and continues to raise his voice on the issues of public interest. I invite Mr. Faratullah Babar to share his views with the audience.
Bismillahirrahmanirrahim. Thank you, Honorable Speaker, for the very warm introduction. Honorable Speaker of National Assembly, Raja Parvez Ashraf Sahib, the Honorable Deputy Chairman of the Azerbaijan Parliament, Mr. Adil Abish Oglu, former Acting President of Pakistan and Chairman Senate Farooq Naik Saab, and eminent jurist, Law Minister, Senator Azam Nazir Tarar Saab, Excellencies, leaders of the political parties, members of parliament, members of academia, media, ladies and gentlemen. It's indeed a great personal honor and privilege for me to be addressing this distinguished gathering, these luminaries, on the International Parliamentary Convention. I should like to begin by congratulating the Speaker of the National Assembly, Raja Parvez Ashraf Sahib, who thought of celebrating 50 years of Pakistan's constitution. This Raja Sahib will always be the first line and very important line in your biodata, that when Pakistan was celebrating half a century of its constitution, the person who led these celebrations was Raja Parvez Ashraf Sahib, whom this very constitution is a distinct honor for him, because this very constitution, when it was framed, he must have been a child of 10 to 12 years. But this constitution made him the Prime Minister of Pakistan. This constitution made him the Speaker, the custodian of the House. And this honor will always be an important line in his biodata, which nobody, Raja Sahib, can take away from you. No ordinary person and no chief, whether in Islamabad or Rawalpindi, can ever take this honor from you. And for this honor, well, you may have deserved this honor, and the respect goes also for the party to which you belong, and the party's leadership also. But at the same time, let us not forget that Raja Sahib, in Saadat Bazore Bazu Nest, in Saadat Bazore Bazu Nest, Ta na Bakshad Khudae Bakshinda. Raja Sahib, we're talking about the constitution in the changing world, and what are the challenges? I have identified 4 major challenges. And these are the challenges which are common not only all constitutional democracies in the world, but these challenges are more pronounced in a constitutional democracy like ours, like Pakistan. In my view, the foremost challenge to constitutional democracy anywhere in the world, but more so in Pakistan, is what the Honorable Acting President of Pakistan, a short while ago, stated: the non-state actors, the militants, the extremism. And what is the challenge? The challenge is that if in this fight you lose and the militant wins, that means the end of constitutionalism. So you can't afford to lose this fight. You must win. Because if the militant and the non-state actor wins the fight, this house is gone. The constitution will be the dustbin. But, Honorable Speaker, there is a side also. When you are fighting the militants, in order to exterminate them, there are demands from you and from the House. And the demands are from the security establishment that they want more and more powers to fight the militants. So you have to strike a balance. And this is the challenge of a constitutional democracy. They demand more powers, and the exercise of those powers erodes constitutionalism, erodes fundamental rights. So while you cannot afford to slacken the fight against the militants, you also cannot afford to give unbridled and unchecked powers to the security establishment. And this is the challenge. And the Honorable Speaker knows, and who would know better than him, that there was a challenge to us when there was a demand for setting up military courts, which were completely eroding the constitutionalism. But it was the wisdom of people like Honorable Speaker and the political parties' leaders sitting here that they allowed military courts, but with a sunset clause. So you have to face this kind of challenge. And Honorable Speaker Sahab, the challenge is dramatized when, and I don't name any country, but if there is a perception that in any constitutional democracy, the non-state actors have the backing of some elements of the state, then the challenge becomes more profound. And it is in such situations when the honorable members of the parliament and the speaker of the parliament will have to play a very critical role. The second challenge that I want to place before this distinguished gathering, which all constitutional democracies face, but again, not as much as in Pakistan, and that is the rise of populism. And we have witnessed the rise of populism in Pakistan. And when populism rises, democracy, democratic institutions, and the constitution becomes the first casualty. So we are confronted with the challenge of populism. I don't want to name anybody. It will be unfair. But you and I, and everyone knows that we are passing through a phase of extreme populism in Pakistan. And this poses a great challenge to constitutionalism, which we have to address. The third challenge, Honorable Speaker Sahab, in my view, is the polarization. To some extent, as the Honorable Law Minister had pointed out, that polarization is inevitable because political differences are, in a way, polarization. But when the polarization becomes so deep and so pervasive that it does not remain confined to political parties, it creeps into the state institutions. When the state institutions are polarized from top to bottom and left to right, now that is pretty serious polarization. And you all know we have witnessed what kind of polarization we are witnessing, not only between the political parties or within the political parties, but also within the state institutions which have been considered to be sacrosanct, whether those institutions are in Islamabad or in Rawalpindi or anywhere in provincial capitals. The state institutions have been polarized, and this poses a very serious threat to constitution in the changing environment of Pakistan. Honorable Speaker Sahab, another challenge, in my view, is the concentration of wealth in the hands of a few people. In a sea of poverty, when the wealth is concentrated in the hands of a few, those few cannot survive for long. There will be upheaval. And this brings me to the idea of equitable economic field. Again, I would not mention any country or the name of anybody, but when the commanding heights of economy, and what are the commanding heights? The commanding heights are business, commercial, industrial complexes, contracting, and the real estate. When all these major business activities and commercial activities appear to be in the control of a few individuals or one institution, then a dangerous transfer of resources is taking place from the underprivileged to the elite. And only 2 days ago, the UNDP report said that the transfer of resources taking place from the underprivileged to the elite is to the tune of $17 billion a year. Now, with this kind of disparity, constitutionalism will be threatened. Finally, Honorable Speaker Sahab, the Law Minister pointed out about the technology and also the fake news. This is really a very serious challenge. With this mobile in the hand of everyone, everyone has become an editor, a publisher, a broadcaster, a reporter, a commentator, a filmmaker, and a publisher. And the time gap between information and dissemination is zero. So what happens? Fake news spreads. And fake news has threatened democracies and institutions. But ladies and gentlemen, it pains me to say that the fake news is not only in the private sector. There may be instances when the state institutions are also involved in fake news. I don't have to go beyond that. But when we address the issue of fake news, which must be addressed, we cannot close our eyes to the fake news being pervaded by state institutions. They are more dangerous because they tend to promote a narrative, a bayaniya, which narrative can erode totally the democratic and the constitutional structure of the country. Honorable Speaker Sahab, what is the way forward? I think that, let me quote from one of the resolutions जो इस कौमी असेंबली ने 10th April को पास किया था. This National Assembly passed 4 resolutions. And one of the resolutions, it began by declaring all members of the Constitution Committee of 1973 and of the 5th National Assembly of Pakistan, which made the Constitution, it declared all of them as national heroes. Good enough. Yes, they were, and they will always continue to be our national heroes. But, Janab Speaker, the same resolution also stated at the end, it declares that all those who abrogated, subverted, and suspended the Constitution of the Islamic Republic of Pakistan and or upheld or otherwise lent legitimacy to the suspension of Constitution, those who abrogated and those who lent legitimacy, the resolution of the National Assembly, which Honorable Speaker presided, says they will always find mention in the National Hall of Embarrassment. So the first step to go forward is to create a National Register of Embarrassment, in which all those names who abrogated or subverted the Constitution, they are mentioned in black register. Honorable Speaker Sahab, I want to thank you very much for the honor that you have shown to me, and I want to thank everyone here for listening to me so patiently. Thank you very much.
Thank you, Mr. Faratullah Babar Sahab. I may also inform the convention that the delegation of Oman is headed by the Deputy Chairman of the State Council of Oman. The Syrian delegation is also headed by Deputy Chairman of Syrian Parliament. I am also pleased to welcome the delegation from the Parliament of Tanzania. The next speaker is Excellency Honorable Adil Abish Uglu Aliu. Now I would like to invite His Excellency Honorable Deputy Chair Milli Majlis of the Republic of Azerbaijan to express his insight. Mr. Adil is a seasoned parliamentarian who was first elected to the Milli Majlis of Azerbaijan in 2000. He was elected a member of the Majlis of the Azerbaijan Republic of the 3rd, 4th and 5th convocations. He also chairs the Milli Majlis Committee for Youth and Sports and is the leader of the working group for Azerbaijani-Kazakh Interparliamentary Connections. Honorable Adil Saab, please.
Çox təşəkkür edirəm, hörmətli spiker, hörmətli konferans iştirakçıları, hər birinizi salamlayıram. Hər birinizə hörmətli spikerimiz Sayba Qafarovanın salamlarını çatdırıram. Qardaş Pakistan xalqının konstitusiyalarının qəbul olunmasının 50 illik münasibəti ilə səmimi qəlbdən təbrik edirəm. Mənim konstitusiyam, mənim azadlıqlarımın zəmanətidir adlı beynəlxalq konferansda iştirak etməkdən məmnunluğumu bildirirəm. Konstitusiya hər bir ölkənin əsas qanunu olmaqla insan və vətəndaş hüquqlarının və azadlıqlarının müdafiəsinin, dövlətin ərazisi, bütövlüyünün və suverenliyinin əsasını təşkil edir. Xalqın vahid iradəsinin ifadəsi olan bu sənəd yenə də məhz xalqın iradəsi əsasında qəbul edilir. Bugün qardaş Pakistan dövlətinin məhz güclü olması səbəblərindən biri də 50 illiyinin qeyd etdiyimiz konstitusiyasında insan hüquq və azadlıqlarının böyük önəm verməsi, onu qorunmasıdır. Diqqətinizə çatdırmaq istərdim ki, bugün 10 may tarixi məhz müstəqil Azərbaycan konstitusiyasının qəbul edilməsi təşəbbüsü ilə çıxış edən və Azərbaycan dövlətinin parçalanmasından qarşısını alan xalqımızın ümumilli lideri Heydər Əliyevin 100 illik yubileyidir. Azərbaycanda konstitusiyanın qəbulu 1995-ci ilə təsadüf edir. Məhz Heydər Əliyev iradəsi əsasında hazırlanmış bu sənəd referendumla qəbul edilmişdir. İnsan hüquq və azadlıqlarının başlıca prinsiplərinin bərqərar olması baxımından konstitusiya böyük önəm daşıyır. Azərbaycan konstitusiyasının 3-cü fəsli bütövlükdə, yəni 158 maddənin 48-i insan və vətəndaş hüquqlarına və azadlıqlarına həsr edilib. Eləcə də qeyd edilən hüquq və azadlıqların qorunması, müdafiə olunması, vəzifəsi qanunvericilik, icra və məhkəmə hakimiyyət orqanlarının üzərinə qoyulmuşdur. Konstitusiyanın 7-ci maddəsində Azərbaycan Respublikasında qanunverici, icra edici və məhkəmə hakimiyyətlərinin bölünməsi qeyd edilmişdir. Hər birinə həsr edilmiş maddələrə əsasən isə hakimiyyətin bu üç qolunun müstəqil idarə olunması və səlahiyyət hüquqları konkret göstərilmişdir. Azərbaycanın ilk konstitusiyasının qəbul edilməsindən 28 ilə yaxın müddət keçmişdir. Konstitusiyanın qəbul edilməsindən bu günədək 3 dəfə referendum keçirilmiş, insan və vətəndaşların hüquq və azadlıqlarının dairəsi daha da genişləndirilmişdir. Konstitusiyada nəzərdə tutulan normalar beynəlxalq aləmdə təşəkkülünü tapmış, qayda və prinsiplər əsasında formalaşır. Qeyd edildiyi kimi, konstitusiyanın əsas mahiyyəti insan hüquq və azadlıqlarını, dövlətin suverenliyi və ərazi bütövlüyünü qorumaqdır. Lakin Ermənistan konstitusiyasında Türkiyəyə qarşı ərazi iddiasının olması deməyə əsas verir ki, belə bir maddənin qanunda yer alması məhz konstitusiyanın mahiyyətinə ziddir. Eləcə də konstitusiyada nəzərdə tutulmuş normalar bəzi hallarda xarici dövlətlər tərəfindən yovuz şəkildə pozulur. Bildiyiniz kimi, Ermənistan 30 il ərzində tarixi Azərbaycan torpaqlarını işğalda saxlamışdır. İşğal dövründə 1 milyondan artıq Azərbaycan vətəndaşı evlərindən qovulmuş, 30 il məcburi köçkün kimi yaşamağa məcbur olmuşlar. Ermənistanın işğal faktı ölkəmizin suverenliyi, ərazi bütövlüyü ilə bərabər həm də vətəndaşlarımızın yaşamaq, mülkiyyət, özlərinə sərbəst yaşayış yeri seçməz kimi təməl hüquqlarını kobud şəkildə pozmuşdur. Faktiki olaraq 30 il müddətində Azərbaycan vətəndaşları bu hüquqlarından məhrum edilmişlər. Nəhayət 2020-ci ildə Azərbaycanın Ermənistan təxribatının qarşısını almış və tarixi qələbə qazanmışdır. Bu zəfərlə həm Ermənistanın təcavüzünü pisləyən BMT-nin qətnamələri icra edilmiş, həm də Azərbaycan beynəlxalq hüquqda və öz konstitusiyasında nəzərdə tutulmuş insan hüquq və azadlıqları, ərazi bütövlüyü və suverenliyi ilə bağlı normalar bərpa edilmişdir. Baş verən müharibələr və digər fəlakətlərlə bərabər insan hüquq və azadlıqlarının təmin olunmasında yaşanan çətinliklərdən biri də məhz pandemiya və digər qlobal hadisələrdir. Məhz son 3 ildə bütün dünyanı əhatə edən COVID-19 pandemiyası həm də proseslərə təsirsiz ötüşmədi. Baxmayaraq ki, 6-cı çağırış Azərbaycan Milli Məclisi hələ pandemiyadan əvvəl seçilmişdir. Pandemiyanın parlamentin fəaliyyətinə də təsirsiz ötüşmədi. İclasların sayı azaldılmaqla bərabər qanunlarda müvafiq dəyişikliklər aparılaraq iclaslar onlayn rejimdə keçirilmişdir. Eləcə də pandemiya dövründə qarşılaşdığımız çətinliklərdən biri də insan hüquq və azadlıqlarının təmin olunması idi. Belə ki, virusa qarşı vaksinlərin əldə olunmasında peyvənd millətçiliyinin olması, inkişaf etmiş ölkələrin daha çox vaksin almasına şahid oldu. Qoşulmama hərəkatına sədrlik edən ölkəmiz baş verən bu haqsızlığa kəskin reaksiya vermişdir. Azərbaycan Prezidenti İlham Əliyevin təşəbbüsü ilə hərəkətin üzvləri adından irəli sürülmüş COVID-19 əleyhinə peyvəndlər bərabər, məqbul qiymətə, vaxtında və universal əlçatanlıqla təmin edilməsi adlı qətnaməsi 171 ölkə dəstəkləmiş və BMT Baş Assambleyasının 76-cı sessiyası çərçivəsində qəbul edilmişdir. Peyvəndlərin ədalətli bölüşdürülməsi və pandemiya ilə qlobal mübarizədə vahid strategiyanın işlənib hazırlanması kimi mühüm təkliflərlə çıxış edən ölkəmizin əsas tələbi insanların təməl hüququ olan bərabərliyi təmin etmək və hər kəsin bərabər qaydada peyvəndləri ala bilməsi şərait yaratmaq olmuşdur. Bugün internet və sosial media həyatımızın ayrılmaz tərkib hissəsinə çevrilib. Heç bir halda bunu həyatımızdan çıxara bilmərik. Təbii ki, əlaqələrin qurulmasında, yerli və beynəlxalq təcrübələrin öyrənilməsində çox mühüm alət olan internet həm də dünyaya açılan bir pəncərədir. Lakin bu alətlərdən düzgün istifadə edilməməsi özü ilə birlikdə fəsadları gətirməkdədir. Alətlərin düzgün idarə edilə bilməməsi təəssüf ki, bəzi hallarda insan hüquq və azadlıqlarına qəsd edir. Sosial şəbəkələrdə və internet resurslarında yer alan hədə-qorxu və kiber zorakılıq real dünyanı hədəf alır. Burada yayılan təqibləri, zorakılıq və qətillərlə bərabər hətta soyqırım və etnik təmizləməyə gətirib çıxaran fikirlər söylənilir. Qeyd olunan kontekstlərdə insan hüquqlarının pozulmasının qarşısını almaq həm beynəlxalq, həm də milli qanunvericiliyin üzərinə düşür. Cəmiyyəti bu cür qəsdlərdən qorumaq məqsədi ilə qanunvericilikdə müvafiq düzəlişlərin aparılması məqsədə müvafiqdir. Biz hesabatlılıq, əlaqə və nəzarət kimi alətlərdən istifadə edərək sosial media ilə bağlı qanunlarımızı təkmilləşdirə bilərik. Bu resurslardan səmərəli şəkildə istifadə edərək müsbət təcrübəni öyrənə və qanunvericiliyimizdə tətbiq edə bilərik. Təbii ki, söhbət heç bir halda sosial şəbəkənin və medianın məhdudlaşdırılmasından getməməlidir. Artan iqtisadi dövriyyə, qloballaşma və miqrasiya və s. kimi mühüm proseslərin fonunda qanunvericilikdə əksini tapmış hüquq və azadlıqlarının qorunması da özü ilə ilk plana çıxarılır. İkili konstitusiya sindromu dediyimiz hadisə özlüyündə qloballaşmanın, iqtisadiyyatın, insan hüquq və azadlıqları ilə bərabər şəkildə inkişafına təmin edən bir faktordur. Təbii ki, beynəlmiləşməkcə mövcud qanunvericiliklərdə bu sahədə əlavə və dəyişikliklər edilməlidir. Xüsusilə bugün öz əksini tapan 3P, publik-privat partnership, dövlət, özəl sektor tərəfdaşlıq kimi anlayışların milli qanunvericiliyə gətirilməsi mühümdür. Hörmətli konferans iştirakçıları, eləcə də yeni qanunlar heç bir halda fundamental hüquq və azadlıqlarla rəqabətdə olmamalıdır. Belə ki, bərabərlik hər zaman özünü hüquq və sosial sahədə əksini tapmalıdır. Fərdlər biznes mühitində rahat şəkildə iştirak etməli, qanun onların hüquqlarının qorunmaqla bərabər həm də təşviq etməlidir. Bugün ölkəmizdə iqtisadi zonalar yaradılıb, vergi və kömürlük məcəllələrində aparılan dəyişikliklərlə nəticədə bu zonaların fəaliyyət göstərən sahibkarlar gəlir vergisindən, rüsumlardan azad ediliblər. Qanunvericilikdə aparılan təşviqlə bağlı belə dəyişikliklər iqtisadiyyatın inkişafının hasar rəqabətinin stimullaşdırır. Sonda diqqətinizə görə minnətdarlığımı bildirir, konferansın gedişinə uğurlar arzu edirəm. Əminəm ki, qarşılıqlı müsbət təcrübələrin öyrənilməsi inkişafımızı daha da sürətləndirəcəkdir. Diqqətinizə görə təşəkkür edirəm.
Thank you, Excellency, Honorable Adil Abish Oglu. Ladies and gentlemen, the plenary session is concluded. Now I ask the Secretary to give us the next program.
Thank you very much, sir. So we will be breaking out for lunch now. The lunch is served on this floor and the ushers will lead you to the venue of the lunch. The lunch is from 1 o'clock to 2:30. It's lunch and Zuhur prayer. After the lunch break at 2:30, we will be breaking out in 3 sessions as I had informed you during the inaugural session. The first breakout session is taking place here in this hall, and the topic is Federalism and Devolution of Power, Challenges and Opportunities. Madam Nafisa Shah would be chairing this session. It is here in this hall, whereas we have 2 other sessions. The other breakout session, Constitution and Representation, Ensuring Free and Fair Elections, is in committee room number 2, which is a floor below this floor, on floor number 1. Our ushers will be taking you there. And the third session is on the climate justice, a multilateral framework for global responsibility in climate change, which is in committee room number 5. The ushers will take you there. After the breakout sessions, we have our closing plenary, which is a very exciting one, because the topic of the plenary is separation of power, balancing executive, legislative, and judicial functions, and we have 2 very luminaries attending this session, who are the keynotes, Maulana Fazlur Rahman, Amir Jamiyat Ulama Islam, and Mr. Afrasiab Khatak. Both of them would be the keynotes for this session. That plenary will take place, the concluding plenary will take place here in this hall at 4 o'clock. So I look forward to a very eventful day, and as we break for lunch, I request you to kindly follow the timing. Thank you very much.